Good morning, good morning, good morning. It's Thursday, May 29th. It's day 23 of 6,897 of the Karen Read Retrial. We are in week 6. Yesterday, when we left off, there had been a voir dire very quickly to deal with whether or not the defense would be able to ask Dr. Welcher more questions about Dr. Scordi-Bello, the coroner, and about Trooper Paul. And if you watched today's case brief, you will see that we took a look at the things that I thought I remembered from where things were placed on Trooper Paul's layout versus where things were placed on Dr. Welcher's layout. And did he rely on Trooper Paul? And what does reliance even mean? Emily, are lawyers going to fight over what the word rely means? 100%. Does rely mean that he made his decision based on that decision? Does rely mean he looked at those pictures? Does rely mean that that's where he got the location of items from? Does rely mean that that's where he got the photos of the inside of the car or the mileage from? What does rely on it mean? Even if he came to independent determinations with independent testing, were there still parts of what Trooper Paul did that he relied on, allowing the defense to then ask more about Trooper Paul's report? I want to see how the court rules because this witness is probably going to be on the stand at least the rest of today. Remember, today is a half day, so no lunch in court today, just a quick morning break and a half day. And then will this witness be done today? I don't know. I really don't know if this witness is going to be done today. We might go into tomorrow, and tomorrow is supposed to be a full day in court. We'll see if that changes.
I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scordi-Bello.
Wow.
So that's my ruling. Let's bring the jury in. Well, come over here because they're on their way.
And the court ruled immediately that there was no allowance for a line of questioning regarding Trooper Paul and no allowance for a line of questioning regarding Dr. Scordi-Bello. I think that it is fair game to cross-examine the Commonwealth's new accident reconstruction expert about what they relied on from the previous accident reconstruction expert. Does that mean they get into all of the opinions from the previous accident reconstruction expert? Not necessarily. But can you ask about the information that was used? You should be able to. But if the defense wants to call Trooper Paul, then the defense is going to have to call Trooper Paul under the court's order. With regard to Dr. Scordi-Bello, I think it's a bit of a closer question depending on what the defense wants to ask. The defense can ask about Dr. Scordi-Bello's findings, but not ultimate opinion because it's just hearsay as to this witness because that wasn't relied on. They did rely on the autopsy report, but whether or not the ME says, oh yes, this is common in accidents or not, isn't what was relied upon by this expert. So I think it's a closer call for me with the ME than it is for Trooper Paul. Now, what the full line of questioning they wanted to get into was about the key cycles. I don't know if they can get into the full line of questioning about how Trooper Paul fixed the key cycles, but they can ask about you used these things from Trooper Paul. There has to be a line between it. So I don't know the entire line of questioning they wanted to ask because that was done at sidebar. But she has cut off the entire line of questioning, it seems. Some of that should have been allowed in. Not all of it. However, if the defense chooses to call Trooper Paul, we have heard that Welcher will be back as a rebuttal witness, and then it would be asked about at that point in time. So that can happen.
Some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
Well, if you
and as you
reviewed
sit
them,
here today, it's your testimony. You don't know whether in any of the reports of the Massachusetts State Police there is an answer to the question of whether there's any connection at all between the glass found in the snow in the glass on the bumper?
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Oh, they did. They did.
Assume
They
that
100%
there has been
did.
testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from.
Right.
But we still have a whole bunch of other elements. So I don't think it would affect the end results.
So would it
I
have
don't
any
think-
part in your analysis
Yeah,
with my
some.
assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes. I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that
It's a great line of questioning. Isn't this one of the assumptions you made? You saw a glass at the scene, you saw glass on the bumper, you held the glass like this, you assumed that that broken glass ended up on the bumper. But what if it didn't? Did you even consider that? It's a good question because as you start, again, House of Cards, as you start pulling out the foundational pieces, and the foundation of a lot of this is assumption, as you start pulling out those pieces, it starts to crumble the foundation of the opinion.
your testimony is that that is a 3D image, not a Photoshopped step bumper cover. Is that correct?
So we have mapped the color over the 3D scans.
Mapped
We used
the color
two
over the
separate
3D scans?
If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the
What?
bumper cover, not the taillight.
Okay, I'm explaining the process.
I just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody
So-
else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to
Did
do.
you do it?
I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, this, and this. Use
So
the
you
hand
don't know.
scanner, go scan the light. I need to put this back in
So you
because it
don't
was
know.
missing when we got to it. So no,
Okay, but how did you add in a taillight? Did you splice it from the other Lexus? Because you scanned it with the taillight missing, so how did you add it back in?
I'm not punching the keys.
What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine?
We've gotten to all of the really interesting questions today. These are the questions we all wanted to know. What ride height did you use? So you've got a car that can move 5 inches up or down. You've got a berm that's 4 inches. So you've got a lot of factors for variance in that blue paint experiment. And chat, if all of your takeaways are inches matter, that's where we're getting to. Inches and seconds.
Whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr.
I want to know about the
O'Keefe.
paint
If it
experiment.
was even possible, what did you use for a measurement
We
of the suspension?
matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
But that was parked.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus.
I'm glad they
match
considered
that.
it.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document at all?
Stop flipping.
Yes.
Where?
Stop flipping.
Slide 107.
Can we have slide 107, Mr. Wolf?
And then if you could zoom in
I'm
on
glad
the
to know
lower
they consider
photograph.
it. Truly.
The gentleman with the blue shirt. Zoom in a little more, please.
Kind of surprised, actually.
So if I may, we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photos. So I don't care what the numbers are. I care that the height is the same.
Okay, so I just heard you say, if I heard correctly, you don't care what the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand. So what was the suspension height of Miss Read's Lexus at 5:07 a.m. on January 29th, 2022, while at One Meadows? And
I think this is the first time I've ever heard an engineer say, I don't care what the number is. And I'm kind of buffering on that.
between Miss Read's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided. They made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at
Good
34
questions.
Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man.
He's going to say that didn't register either, because it didn't. This is not a good question, Alessi. This is not a good question, because it didn't register either. He has said repeatedly that the trigger event was the backing up at speed, not the contact with John O'Keefe. Alessi, you are walking in to where you don't want to. This is not the right question. This is not the right question, Alessi. But you want us to believe that the glance to John O'Keefe registered. Wrong question. Nope. The backing event
Did register an event on the Lexus, correct?
No. The impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. They don't call stop codes and things like that. But that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred.
Right.
Because the tech stream doesn't tell you that.
Thank you.
You're welcome.
Exactly my point.
right.
The texturing information
Could have been asked.
doesn't tell you when a collision occurs, does it?
Correct.
Surprising to me that we are at the end of cross-examination at the time that they took the morning break. I think cross went a lot smoother today than it did yesterday. That's not because the witness was easier. It's because Alessi took a bit of a different approach for most of the cross-examination. The points that I wanted to hear about, I think were mostly addressed. Alessi asked about something that the chat had been asking about all day yesterday. What about the suspension system? What about the fact that when the Lexus parks, it lowers down, and then when you start to drive, it raises up, and there are different suspension levels? How much variance is there in that, and was that considered? And the witness said, when the Lexus was measured at Canton PD on February 1st, we used that height. Well, that's the parked height of the vehicle. So they did not account for the relative suspension height that can vary and change when they did the models of the Lexus backing into the Traverse and when they did the blue paint experiment, video, whatever, when the Lexus was backing at 34 Fairview. So the height variance of the suspension was not accommodated for, or it seems even considered. And the height variance of John O'Keefe, whether at ground level, at the berm, or the yard level, were not accommodated for. They also asked about whether or not the tech stream registered a collision event when the Lexus hit the Traverse, and it did not, which I don't think we had heard answered yet. And it also did not register any collision event with John O'Keefe, which we knew. And Alessi asked about the 3D modeling of the Lexus vis-a-vis the Traverse and how the 3D modeling was done and if the 3D modeling was overlaid, because some of the 3D modeling looks different. I think all of that is laying foundation for when we get to the defense experts. Maybe not so much for the answers being impactful to the jury at this moment. We also saw the groundwork that Jackson had laid in previous cross-examinations come into play here, because we saw a lot of questions early on about the glass on the bumper of Karen Read's Lexus and the assumption that this expert made that the glass found near John O'Keefe and the glass in the bumper were the same. And what we learned is that this expert thought that the lab results came back inconclusive. Well, the lab results did not come back inconclusive. And the jury would likely remember that well because Jackson made such a good chart. I found that chart to be incredibly helpful. It's memorable, and it really synthesizes the data about the glass on the bumper of the car and the broken glass found near John O'Keefe at 34 Fairview by the leaf blower crew. And you see that come back around when this expert says it was inconclusive. I remember the chart. No, it wasn't. And showing that those assumptions had already been disproven in other data is helpful to the defense to argue it down the road. And I think that the groundwork laid to get that chart in made that information much clearer than last time, because the jury sitting there going 3-3 and is it the same as 17 or 11-12 is so hard to keep track of. So the simplification of it, I think, was well done this time.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out, and David said, yeah, then you have some element of culpability.
Your Honor, the Commonwealth rests.
And there they are. Done.
Karen, what can we expect from the defense? Will you testify?
TBD. How long will your case last? 1.5 to 2 weeks. How are you feeling after today? I feel very good, thank you.
I'd like to call Trooper Paul. Is that the only way you can get his testimony in at this point, if you do?
It seems that way, yes.
Any
Yes.
decision about Trooper Proctor, Karen?
TBD.
Paul's coming up.
Oh, guys. Oh.
Any idea who the first witness will be for your defense?
Not just over.
Based on Karen Read's statements after court today, it seems like the decision on Trooper Proctor is TBD, and that their first expert or their first witness tomorrow will be their tech expert, who is going to talk, I imagine, about the timing of everything that we've seen from Welcher to Jessica Hyde. That's probably a multi-day witness right there. Does it surprise me that that's their first witness? Well, I wanted it to be Trooper Proctor. Why? Because that would be fascinating. Does it make sense to lay out where the time variances are before you call the rest of your witnesses? Sure it does. And what about Trooper Proctor? Well, Karen Read said after court, that is still to be determined. And her testifying is still to be determined. That I don't doubt. That is a decision that you have to wait and see how things come in and what happens. But the prosecution is, it feels to me, using the clips to almost push that. But they can use those clips for whatever they want, because the ultimate choice to talk to the media or not talk to the media was with Karen Read. Once you talk to the media, the prosecution can choose how to use it. And they're going to. And they're going to use it to make everything look as in a line with their view of the case as they can. So at the end of day 23, the Commonwealth said they would be 23 days to present their case. It is midday on the 23rd. The Commonwealth has rested and they are done. The final thing they played in was a clip from Karen Read's interview with Discovery ID. And we did not see argument on the motion to dismiss that will be made by the defense at the end of the Commonwealth's motion. That will be argued in the morning. I don't think I've ever seen a case where the motion to dismiss at the end of the case was granted. I'm sure it happens. I just haven't seen it. So the defense is going to start with their witnesses tomorrow, full day of court tomorrow, with the jury coming in a half hour later to accommodate for those arguments, which means we will be here on time for those arguments. So we'll watch the argument. They gave it about a half an hour. The judge is going to say that a reasonable jury can conclude there's enough evidence here to find these counts. That's not surprising. I think that there are difficulties, to put it mildly, in the Commonwealth's case, but you have an expert saying that the injuries are consistent with the collision, that the damage to the vehicle is consistent with the collision. You have the gas pedal and the voicemails, which is what I think the Commonwealth will argue goes to second degree for count 1. And when the court evaluates this, the court takes everything in the light most favorable to the Commonwealth. So if it's could be this, they take everything in the light most favorable to the Commonwealth for that motion, including Karen Read's statements. Those are in evidence, including all of the witness testimony. So there's a lot this jury does not know. It's a strategy from the Commonwealth that I don't know how will play out. Because last trial, the strategy from the Commonwealth was literally...
Mention it all. Mention it all.
It felt to me like Attorney Lally said, this is every name that's been mentioned in any police report ever. And I am going to call every single witness. And I was critical of that too. There were some witnesses that were just not needed. But Lally was just like, we're calling everybody. Literally everybody. There's not going to be a name that this jury hears that is not going to have somebody sitting on the witness stand and is going to testify. Every single one. That is not the strategy this trial. The Commonwealth narrowed it down significantly to what they think are their critical witnesses, but they left out some witnesses whose names have come up over and over and over again. And I have to wonder what the jury thinks about Proctor. Does the jury think former Trooper Proctor means he's been terminated? Or does the jury think former Trooper Proctor means that he is no longer with us? What does the jury think about why the Commonwealth hasn't called them? Because the jury will fill in the blanks from their own life experience. And if any of the jurors are sitting there going, oh, well, they didn't call him because they can't, it's going to be a real surprise if the defense stands up and says, we would like to call former Trooper Proctor. I think former indicates that he's been terminated, but I think a jury could also think that he's unavailable to be called because he's deceased. I think there's room for them to think that either could be true. So wouldn't it be real interesting when the defense calls and then the jury is like, what? What do you mean you didn't call him? Jurors do not like feeling like things are hiding. And so the strategy of keeping out Higgins and Proctor and Albert and, I mean, even Ricky, whose truck it is, could go badly. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.